Hello everyone, I'm George from Ireland, and in this video I'm going to talk about judicial independence. So there's the Cabinet Manual, a booklet for, well, the Cabinet, and it says that there's a long established principle that the judiciary is independent of both the government of the day and Parliament so as to ensure the even-handed administration of justice. Close quotation. It goes without saying it's also independent of any pressure groups. So the judges are to make their decisions without fear, without favour, not trying to help or harm anyone, doing it in a disinterested manner in consonance with principles of jurisprudence and justice. So, and they must recuse themselves from cases if they have any interest in it, as in, not interest as in curiosity, but any advantage could accrue to them from ruling from one side or the other, or it could even be perceived that an advantage might accrue to them in a pecuniary sense, or just in terms of being a ruling in furtherance of a cause that he or she believes in. So there is structural independence of the judiciary in the United Kingdom, particularly concerning ourselves with England and Wales, though. But that wasn't always the case. So remember, there's the Constitutional Reform Act in 2005, which I've name-checked numerous times in these videos, and that really transformed the position of the Lord Chancellor, perhaps the oldest governmental office in the United Kingdom. Well, and even obviously long before the UK existed in England, going back to Anglo-Saxon times. So that also took the Supreme Court out of the House of Lords. It used to be the Appellate Committee of the Supreme Court, which was the highest court in the UK. We normally say it was a House of Lords ruling. It wasn't all the hereditary peers, it wasn't the Anglican bishops, it wasn't the life peers, it was only the law lords. Anyway, so the UK now guarantees a continuance of judicial independence. So the Constitutional Reform Act in 2005 spelt that out in black and white, just in case there was any doubt about it. So what does the Constitutional Reform Act say? It says the Lord Chancellor, other ministers of the Crown, and all the responsibility for matters relating to the judiciary and otherwise the administration of justice must uphold the continued independence of the judiciary. That ought to be implicit. Now, and this is about the UK as a whole. There are specificities referring to England and Wales, and then others to Scotland, others to Northern Ireland. So let's consider judicial accountability. So a tricky question arises when we think how judges are to be held to account, because they're not brought before Parliament to be questioned like government ministers. Why did you do this? What are your plans for that? What's the budget? How come you failed? And things like that. What are you going to do about such and such a problem? No, but judges are evolving the law, and they hold a very prominent position, public position, and their rulings, they affect us for better or worse. So let's think about Professor Vernon Bogdanor, Professor of Politics at Oxford University, who had David Cameron as his pupil in the 80s. But Professor Bogdanor said you have to tell apart different kinds of accountability. And Bogdanor says accountability to Parliament is sacrificial accountability, because they can be got rid of through this. But there's also explanatory accountability, which is what is applicable to judges, as they have to explicate their rulings and why they made such a judgment and so forth. So Bogdanor says that explanatory accountability is consistent with judicial independence. It doesn't have to degrade it in any wise. So the judges also have a security of tenure. Once you're there for a set number of years, unless you commit an illegal act. But so it's not a lifetime as it is in the US Supreme Court, because if they didn't have security of tenure, judges in the UK, if they ruled in a way that the government of the day found uncongenial, they could boot this person out, and a judge might find his or her willingness to thwart the government impaired. Ooh, I don't want to risk my career, so I better not rule in a way that the government finds irksome. So judges are now required to publicly state their reasons for the judgments they have arrived at. and so they publish their judgments. So that's maybe not what most people regard as being accountability. There are obviously appeals, and you can appeal to a higher court, say if you think the decision was wrong, but usually it's not wrong. Usually it's upheld. There's also this principle of stare decisis, as in stand by the decision. So you have to have some sort of consistency and predictability. But there has to be a mechanism to correct wrong decisions. Judges can err in law. I mean, they're human too. They just get it wrong, a plain mistake. Remember one of Lord Bingham's lectures on the rule of law several years ago, he said, because of this legislative hyperactivity, it's often very difficult to tell what the law is, because there's sort of quite a bit of primary legislation, these statutes, so much secondary legislation, European legislation, and rulings by very different courts. It's just like a rainforest of laws they've got to get through and find what the relevant is. What's the most recent one? Has one impliedly overruled and replaced an earlier one? So it's very confusing, even for the experts. Anyway, so let's see how people have critiqued the judiciary. So there is this convention that politicians don't comment on the rulings that judges make. Now, David Blunkett, he was the Labour Home Secretary from around 2001 to 2004, and he was notorious for publicly lambasting judges when he found their judgments to be irritating, and saying, oh, they shouldn't care about these abstract freedoms, don't stop us getting blown up from terrorists, you mustn't undermine my control orders, and so forth. And likewise, judges would find it unseemly to comment on the political sphere. You know, they don't belong to any political parties. They're not allowed to in the Supreme Court. They actually are allowed to lower down. I'm not aware of any judges who are, or who campaign. You probably wouldn't be promoted to the bench if you were known to be politically active. But what was I going to say about these judges? They're not saying vote Labour, or we must all oppose Brexit, or something like that, even if that's what they fervently believe. Maybe be more honest if they were open about their beliefs. Anyway, so sometimes there could be a motion about removing a judge, and they might debate that. But as I say, this convention has broken down, and increasingly politicians do make scathing remarks about judges in public. The judges tend to refrain from doing that. So the Human Rights Act 1998, which kicked in 2000, is quite contentious, and some unpopular rulings have been made on the basis of that. So let's look at there's the Miller case, and that touches on how independent the judiciary is. So anyway, let's consider impartiality. So there was Stephen Steadley, who was a judge, and he's retired some years ago. So he said what the distinction is between impartiality and independence. Impartiality is a state of mind. In the vocabulary of the judicial oath, the absence of affection or ill will. Independence is a state of being, freedom from what the judicial authority calls fear or favour. So let's expand on fear or favour. Fear, I don't want to lose my job as a judge, therefore I won't make a ruling that the government will dislike, or something like that, or I could have my salary cut, or that would be unpopular. The press will have a field day, they'll slag me off, so I won't do that. No, you do the right thing. Or favour, I'm going to do this because I want to ingratiate myself with the opposition party about the win of the election, or whatever big company, then they offer me a directorship or something like that. Or my sister has shares in such and such a company. No, that would be, or I like that person, or I feel sorry for that group. No, that should be out of your mind. So there is obviously Lord Hewitt's famous dictum of 1923. He was some sort of senior judge, I can't remember what it was, in R and Sussex, such as Sussex Magistrates ex parte Macarthur. He said, justice must not only be done, it should manifestly and undoubtedly be seen to be done. So must have the appearance of justice as well as actuality, because otherwise that would undermine public trust in the whole system. We want to avoid bias. Now, there was a case concerning bias in R and Bow Street Metropolitan Stipendiary Magistrate ex parte Pinochet Ugarte number 2, it's 1999. So the former president of Chile, Augusto Pinochet Ugarte, came to the United Kingdom in 1998 for a back operation. He was met at Heathrow by British diplomats. They were extending to him the usual courtesies to a visiting foreign dignitary, and a retired head of state. Just days later, he was arrested and served an arrest warrant because Spanish judge Baltasar Garzon had issued some arrest warrant claiming that General Pinochet had committed murder when he was ruling Chile from 1973 to 1988, if memory serves. But anyway, on the Pinochet case, there were extradition proceedings, and one of the lords who sat on this was Lord Hoffman. Now Hoffman had a connection to one of the intervening parties in the case. He was chairman of a charity which was directly connected to Amnesty International. Now, Amnesty had been campaigning fervently for General Pinochet to be extradited to stand trial for various indictable offences. Anyway, so Lord Hoffman had not declared his interest, his connection to Amnesty International. This was held to be deeply unseemly, so he had to recuse himself. Anyway, there's much comment on about in the Law Society Gazette. It was seen as a bit of a blot on Lord Hoffman's career. He resigned not very long after. The South African barrister, who then became a judge, had a glittering career in United Kingdom. So anyway, there's another example which connects to the Supreme Court. So just before the 2005 Constitutional Reform Act, go back to 2004, there was the Hunting Act in 2005. So this is forbidding people to hunt with dogs, particularly stopping fox hunting. So no more hunting with hounds. Reynard was going to be safe, but there was a ruling on this is law about hunting with the hounds, and two of the judges, law lords, was Lord Scott and Lord Hoffman, and when they've been in the House of Lords, they voted in favour of this hunting with dogs act. So they couldn't sit in judgments on they had voted for, because whilst law lords generally didn't vote up until 2005 in the House of Lords, they still had the legal right to, and they occasionally exercised that, which had obviously impaired certainly the appearance of their impartiality. So they recused themselves, which is they removed themselves from the case. Anyway, so Lady Hale, who was president of the Supreme Court, she just retired last year. She made a speech, but not as part of a court case, in another forum. This is before the Supreme Court heard a case pertaining to Article 50 of notice. Because remember, in 2017, the UK triggered that Article 50 of notice, giving the European Union 2 years' notice that the UK intended to withdraw from the European Union, set the clock ticking. And if no agreement was reached within 2 years of that Article 50 notice, the UK was automatically out of the European Union. But there was a case about that, Miller and Secretary of State for exiting the European Union, a 2017 case, went all the way to the UK Supreme Court. You might remember Miss Miller was this city financier and passionate anti-Brexit campaigner. So some people thought it would be deeply inapposite for Lady Hale to sit on this case when she'd made some remarks about Brexit that some people thought showed that she was a Remainer. Now, these judges, they're highly intelligent people. They keep abreast of political developments. They're gifted in the humanities, the sort of people who are really au fait with what's happening in politics. So, of course, they have opinions. They don't opine in public. Are they all Remainers? I don't actually know. You've got to have someone in charge. They're all going to be humans. Humans have opinions. Unless you're complete ignoramus, you'd have a view on this. So we can't have robots decide, so we just have to trust them. So let's look at how judicial appointments are made. That Constitutional Reform Act set up the Judicial Appointments Commission. It decides which people are going to be the candidates for the bench. That was a major overhaul of the system. Hadn't been very systematic beforehand. Previously, the Lord Chancellor had appointed people, and he was a cabinet minister. He was a partisan figure. He was either Labour or Conservative. So the Judicial Appointments Commission, JAC, it suggests candidates to the Lord Chancellor, and who still has a role to play in appointments, but it's much more restricted than it was beforehand. So why, remember, Lord Chancellor has got the title Secretary of State for Justice. Lord Chancellor, Secretary of State for Justice, same person. Maybe just a double title. Lord Chancellor and Secretary of State for Justice. So he can be called to account before Parliament. So he then advises the Queen who to appoint, and of course, Her Majesty always acts the advice of ministers is just a rubber stamp, the merest formality. So there's the JAC. There's also the conduct ombudsman, and he or she works in conjunction with the Ministry for Justice. So the conduct ombudsman has to examine how any complaints are handled. It was to do with the judicial appointments process. Was someone not given fair consideration? Was someone shown favouritism, and so on? And the conduct ombudsman also looks at judicial behaviour. Have they behaved in a manner which has brought the judiciary into disrepute? Because they must always have regard for the good name of their profession, because they have the public trust. They get this high salary. It's important that they conduct themselves in a manner which doesn't disgrace the judiciary. So the JAC has also a duty under statute to pick candidates only on the basis of their deservedness, their erudition, their general respectability, how suitable they are to be judges. To pick people who are of good character. What does that mean? Obviously, can't have committed a crime, but there shouldn't be a question mark over the person's reputation. Someone like Brad Kavanaugh, you might remember that American judge in the US Supreme Court against whom a rape allegation was made. Now, we don't know it to be true. It might be completely false, but certainly there is a doubt over his reputation. He has no right to be a Supreme Court justice. I mean, he is now, but he never right one before then. It was like an honour. They could choose to confer it on somebody else. So the JSA also has to bear in mind that it needs to diversify the composition of the Supreme Court bench, because they can't all be white males. And I think of the 12 of them, I think around 2 are women, and none of them are non-white. There have been some people who are Jewish, so arguably ethnic minorities. Overwhelmingly, they grew up in upper middle class families in southern England, usually went to independent schools. Of the 12 of them, 11 of them went to either Oxford or Cambridge, 4 of them went to Harvard. You see, they often gone to more than one university, and so on. So trying to have more women, more ethnic minorities. One of them is gay. I can't remember who it is, and he brings that up. So that's just a little bit about the judiciary. So you should know expressions like who the Lord Chief Justice is in charge of the criminal division, the Master of the Rolls in charge of the civil division courts, know about senior president of tribunals, and so on. Have a good look at the JAC website. So that's all for the moment. So please follow me on Twitter, on Instagram, on Facebook, and so on, and book online lessons with me in law and other subjects. Toodaloo.